Section 40.149. May the MRO change a verified drug test result? (40.149a). As the MRO, you may change a verified test result only in the following situations. 40.149a1. When you have reopened a verification that was done without an interview with an employee, see Section 40.133d. 40.149a2. If you receive information not available to you at the time of the original verification, demonstrating that the laboratory made an error in identifying, e.g., a paperwork mistake, or testing, e.g., a false positive or negative, the employee's primary or split specimen. For example, suppose the laboratory originally reported a positive test result for employee X and a negative result for employee Y. You verified the test results as reported to you. Then the laboratory notifies you that it mixed up the two test results, and X was really negative and Y was really positive. You would change X's test result from positive to negative and contact Y to conduct a verification interview. 40.149a3. If, within 60 days of the original verification decision, 40.149a3 sub 1. You receive information that could not reasonably have been provided to you at the time of the decision, demonstrating that there is a legitimate medical explanation for the presence of drug or metabolite in the employee specimen, or 40.149a3 sub 2. You receive credible new or additional evidence that a legitimate medical explanation for an adulterated or substituted result exists. Example to paragraph A3. If the employee's physician provides you a valid prescription that he or she failed to find at the time of the original verification, you may change the test result from positive to negative if you conclude that the prescription provides a legitimate medical explanation for the drug or metabolite in the employee's specimen. 40.149a4. If you receive the information in paragraph A3 of this section after the 60-day period, you must consult with ODAPC prior to changing the result. 40.145a5. When you have made an administrative error and reported an incorrect result. 40.145b. If you change the result, you must immediately notify the DER in writing, as provided in sections 40.163 through 40.165. 40.149c. You are the only person permitted to change a verified test result, such as a verified positive test result or a determination that an individual has refused to test because of adulteration or substitution. This is because, as the MRO, you have the sole authority under this part to make medical determinations leading to a verified test, e.g., a determination that there was or was not a legitimate medical explanation for a laboratory test result. For example, an arbitrator is not permitted to overturn the medical judgment of the MRO that the employee failed to present a legitimate medical explanation for a positive, adulterated, or substituted test result of his or her specimen. Section 40.151. What are MROs prohibited from doing as part of the verification process? As an MRO, you are prohibited from doing the following as part of the verification process. 40.151a. You must not consider any evidence from tests of urine samples or other body fluids or tissues, e.g. blood or hair samples, that are not collected or tested in accordance with this part. For example, if an employee tells you he went to his own physician, provided a urine specimen, sent it to a laboratory, and received a negative test result, or a DNA test result questioning the identity of his DOT specimen, you are required to ignore this test result. 40.151b. It is not your function to make decisions about factual disputes between the employee and the collector concerning matters occurring at the collection site that are not reflected on the CCF, e.g., concerning allegations that the collector left the area or left open urine containers where other people could access them. 40.151C. It is not your function to determine whether the employer should have directed that a test occur. For example, if an employee tells you that the employer misidentified her as the subject of a random test, or directed her to take a reasonable suspicion or post-alcohol test without proper grounds under a DOT agency drug or alcohol regulation, you must inform the employee that you cannot play a role in deciding these issues. 40.151D. It is not your function to consider explanations of confirmed positive, adulterated, or substituted test results that would not, even if true, constitute a legitimate medical explanation. For example, an employee may tell you that someone slipped amphetamines into her drink at a party, that she unknowingly ingested a marijuana brownie, or that she traveled in a closed car with several people smoking crack. MROs are unlikely to be able to verify the facts of such passive or unknowing ingestion stories. Even if true, such stories do not present a legitimate medical explanation. Consequently, you must not declare a test as negative based on an explanation of this kind. 40.151E. You must not verify a test negative based on information that a physician recommended that the employee use a drug listed on Schedule 1 of the Controlled Substances Act, e.g., under a state law that purports to authorize such recommendations, such as the medical marijuana laws that some states have adopted. 40.151F. You must not accept an assertion of consumption or other use of a hemp or other non-prescription marijuana-related product as a basis for verifying a marijuana test negative. You must also not accept such an explanation related to the consumption of coca teas as a basis for verifying a cocaine test result as negative. Consuming or using such a product is not a legitimate medical explanation. 40.151G. You must not accept an assertion that there is a legitimate medical explanation for the presence of PCP, 6-AM, MDMA, MDA, or MDEA in a specimen. 40.151H. You must not accept as a legitimate medical explanation for an adulterated specimen an assertion that soap, bleach, or glutaraldehyde entered a specimen through physiological means. There are no physiological means through which these substances can enter a specimen. 40.151I. You must not accept as a legitimate medical explanation for a substituted specimen an assertion that an employee can produce urine with no detectable creatinine. There is no physiological means through which a person can produce a urine specimen having this characteristic. Section 40.153. How does the MRO notify employees of their right to a test of the split specimen? 40.153A. As the MRO, when you have verified a drug test as positive for a drug or drug metabolite, or as a refusal to test because of adulteration or substitution, you must notify the employee of his or her right to have the split specimen tested. You must also notify the employee of the procedures of requesting a test of the split specimen. 40.153B. You must inform the employee that he or she has 72 hours from the time you provide this notification to him or her to request a test of the split specimen. 40.153C. You must tell the employee how to contact you to make this request. You must provide telephone numbers or other information that will allow the employee to make this request. As the MRO, you must have the ability to receive the employee's calls at all times during the 72-hour period, e.g., by use of an answering machine with a timestamp feature when there is no one in your office to answer the phone. 40.153D. You must tell the employee that if he or she makes this request within 72 hours, the employer must ensure that the test takes place and that the employee is not required to pay for the test from his or her own funds before the test takes place. You must also tell the employee that the employer may seek reimbursement for the cost of the test. See Section 40.173. 40.153E. You must tell the employee that additional tests of the specimen, e.g., DNA tests, are not authorized.